We're on the record in docket 1901206, 1901205, and 1901207. We'll start with 205 first. That's People of the State of Michigan versus David Alfonso Keene Anderson. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Keene Anderson. Stephen, to your right.
And sir, no, that's not today's date. Yeah. Sir, you are David Keene Anderson? All right, thank you. This is the time set for jury trial today. And I don't know, before you start, I don't know if you know this, but we're not calling in juries at this time because of some administrative court decisions based on safety. So that have nothing to do with the panic button, by the way. Mr. Wisty, how are we proceeding today?
Your Honor, the people will be dismissing all three of these cases. I made some phone calls to due diligence to try to track down the witness. I was unable to get a hold of him. He has not appeared this morning, so we're dismissing without prejudice.
All right, and Ms. Robinson, I'm assuming you have no objection to
No
that?
objection.
All right, do we do denali's on those or not? On the dog at large?
Ticket? I believe they came on their ticket, so I believe there is no now.
Yeah, you're right. They're all three on a ticket.
There's
You,
no now.
Ms. Robinson, may I inquire of your client?
Sure.
Mr. Keene Anderson, you understand that dismissed without prejudice means that the people could refile if they choose to, but as of today's date, these cases, all three of these cases are dismissed. Do you understand that, sir? All right, so all three of these cases are dismissed. Good luck to you. All right, thank you. Thank you, Mr. Wisty. Thank you, Ms. Robinson.
No problem.
Thank you.
Mr. Hintz, what case are you here on?
Good morning, Your Honor. John Hintz here on the Case Credit Union versus Samuel Lee Horton. The case number is 18-04539 GCF.
All right, let me see where we stand as to the 830 cases, but and then we'll get back to you. But I've got you on the list.
Okay, good. We have service of process, Your Honor. So
all right, thank
we
you.
should be all set.
Mr. Burnett, what case are you here on?
Good morning, Your Honor. I have a few cases with LAFQ.
All right.
Okay,
So you got those three cases?
correct.
All right, perfect. So we'll wait and see who comes on those cases. Would the person on Galaxy A11 please identify themselves?
Me, I'm Judy
Yes.
Rosenthal.
Jean, and you're here on your 8:30 case today, right?
Yes,
All right. Are you represented by counsel?
Your Honor, that's the victim.
Okay, that's the victim in the case. All right. All right, Ms. Rosencrantz. So I've got you here on that case. You're in the right place. Okay, ma'am?
thank you.
Thank you. Would the person on the LG K30 cell phone please identify themselves for the record? Would the person on the LG K30 cell phone please identify themselves for the record? So we're on the record in docket 22-01324. That is People of the State of Michigan versus Scott Sylvester. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Matt Newberg on behalf of Mr. Sylvester, who's seated to my right.
Okay, and I have this as, and you are Scott Sylvester, sir?
Yes, sir.
All right. I have this set for a final pretrial, no, I'm sorry, a PA 53 hearing set for today. Mr. Wisty, how are we proceeding today?
Your Honor, this is somewhat of a strange situation. The accusations I received have to do with him entering a exclusion zone involving Jennifer Sylvester's work. Ms. Sylvester is not the victim on this case. She's a victim on a circuit court case that's pending. Other than an argument that these violations constitute general contempt of court and a violation of law, I don't see them to be a violation of any specific bond condition in this particular case as it pertains to a different victim. So that's where we're at. I turn it over to defense counsel. How we'd like to proceed.
Thank you, Mr. Witzy. Mr. Newberg?
Thanks, Judge. I received the notice this morning. It looks like, so the prosecution is right. Jennifer Sylvester is a victim in a case that is now in front of Judge, I believe, Aquilina in the circuit court. It looks like there's an exclusion zone violation of my client's tether for approximately 2 minutes. My client has informed me that he spoke to pretrial services about this. He was actually headed back from work. Someone else was driving him at the time. And so they drove through the outer portion of that exclusion zone. If the court can look at the map, I don't know if the court's got the map in front of it.
I do.
It's not near, while it's in the exclusion zone, it's a 2-minute violation, not near this person's work. It doesn't violate any of the court orders in front of this court. This was not brought in the circuit court. So I would just ask that the court dismiss this violation. I will say, I had to meet my client last week after the circuit court pretrial, and he refused to come into the exclusion zone. So I had to meet him at the Wendy's down the road. So he's taking this seriously. I don't mean to have a smile on my face, but it does kind of indicate he's aware of the zone,
Right.
trying to avoid it. So I'd ask the court just dismiss it because I don't believe it violates a court order that this court has issued.
I agree. I don't think this issues but the bigger question is that, and I'm glad you're taking the exclusion zone so seriously, Mr. Sylvester. I'm going to dismiss this case in regards to this court. You still have an exclusion zone with Judge Aquilina. And I think the reason why the probation department was so eager was I have not only one exclusion zone violation, but they're brief. I have got one concerning activity on June 22nd. And then, but that's 55th District Court, that's Judge Allen. And then I have Aquilina Flores on July 26th. So both of those would be circuit court or 55th violations. Just so you know better than anyone that that it's going to go off. And then you want to avoid this. This is exactly what you're looking to avoid, which sounds like Mr. Newberg has indicated is exactly what you're trying to do. Okay. All right. So just so you know, be aware of where you are and understand the exclusion zone until this gets past you. All right. So Mr. Wisty, so I'm going to dismiss the PA 53 in this case in 54A without prejudice. And then you can deal with it in circuit court with whatever you need to do. All right. All right. Anything else for the record on docket 22-01324, Mr. Wisty?
No, Your Honor.
Mr. Newberg?
No, Your Honor, thank
All
you.
right, Mr. Sylvester, good luck to you. Okay.
Have a great week, Judge.
Thanks. Oh, you've got a final pre-trial on August 29th?
Yep.
All right. All right. Thank you. Would the person on the LG cell phone, ma'am, would you please introduce yourself so we know who you are?
Am I the LG?
Charlene,
Uh,
yes, I do.
what's your name?
Charlene Adamski.
Ma'am, how do you spell your last name?
A is an apple, D is in David, A is an apple, M is in Mary, S is in Sam, K-I.
Charlene. Ma'am, what case are you here on?
Case number 2201516 LF or LTF.
Or Wednesday, sorry.
Ma'am, I think your case is is on the Wednesday docket.
Oh, I thought it said 8/8. It says 8/17. I am very sorry.
All right, thank you, ma'am. Just making sure you're in the right place.
Thank you.
So, Mr. Burnett, let's call your civil cases, all right?
Okay, Your Honor.
Let's see. So calling you the record docket 1700942. That's Lafque versus Charlie Warren. Will the parties please introduce themselves for the record?
Yes, good morning, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of Lafque.
And I'm calling the record for a Charlie Warren. Charlie Warren, I do not believe is in the Zoom courtroom, and he's not in the actual courtroom. I'll have Nathaniel just call his name for the hallway, just to make sure. Might want to call all those Warren, Spinner, Fuller, and Horton. So it appears Mr. Warren has failed to appear for the discovery proceeding today. Mr. Burnett, how would you like to proceed?
Thank you, Your Honor. We would like to request of the court that a bench warrant be issued against Mr. Warren with a cash bond and the judgment amount.
And what is the judgment amount in this case?
The balance today is $14,448.
Yeah, that's a pretty sizable sum. I'm going to do 10% of that. So I'll do a bench warrant issued with a cash amount of 10% of 14,000.
Okay.
And there you hold on. So I'm going to have D fail to appear. This was actually scheduled for 8:30. It's now 9:49. So the plaintiff requests a bench warrant issued, and it's issued in the amount of 10% of 14,000. Anything else for the record on that, on this file 17-00942, Mr. Burnett?
I believe that is all. Thank you, Your Honor.
Thank you. I don't know if I have a 12. Let's see. All right, we're gonna go on the record in docket 1201320. That is Lansing Automakers versus Steven Spinner. Will the parties please introduce themselves for the record?
Yes, thank you again, Your Honor. My name is Joe Brunette. I'm filling in for Tim Smith on behalf of LAFCU.
And this is the time set for a discovery hearing in this matter. And I've checked the Zoom courtroom. What is the LGK30? Is that? Sir, on the LGK30, could you please identify yourself?
Samuel Horton.
Samuel Horton. All right. All right, Mr. Horton, you're at the right place. Stand by and we're gonna call your case in just a second, okay?
Okay, I'm not on Zoom.
You're on Zoom, but I can hear you all right on your cell phone. I just can't see you, but that's all right, as long as you're here, okay? Thank you. So we're still on the record in docket 1201320 GC. This is a case called for at 8. It was set for 8:30. It's now 8:52. It appears the defendant has failed to appear. Mr. Burnett, how would you like to proceed?
Yes, Your Honor, we would like to request that a bench warrant be issued in the amount of 10% of the judgment, which is $17,004.
$17,004. Plaintiff requests a bench warrant, DFTA. The amount of judgment is $17,004. The court will set a bench warrant at 10% of that amount. For the defendants failed to appear for the discovery hearing, a bench warrants issued.
I'm sorry, Your Honor. Can I request?
Go ahead.
Can I just request for the record that it be a cash bond?
Yes, you can request for the record that it's a cash bond for $17,004, and I'm going to set it at 10%.
Okay.
And I do have notice of this, that Mr. Spinner had notice at the 8:30 date, and it's now 8:53. Anything else for the record on docket 1201320, Mr. Burnett?
That is all for that case, yes.
All right, thank you, sir. And then, Mr. Burnett, you have one more with us today.
Correct.
That's docket 17-02060 GC. That's LAFCU versus Brady Fuller and Property Preserve Fuller. Sounds like an entity. Will the parties please introduce themselves for the record?
Yes, thank you, Your Honor. My name is Joe Brunette. I'm filling in for Tim Smith on behalf of LAFCU.
And I don't see anybody in the Zoom courtroom or in the waiting room that would associate with Mr. Fuller or Fuller property. Is there anybody in the courtroom? When we have called their name in the hallway. So this was a case set for 8:30. It's now 8:54. It appears that the defendants have failed to appear. How would you like to proceed, Mr. Burnett?
Thank you, Your Honor. I'm not sure what the court has in its file, but the proof of service in my file here, the check boxes aren't marked for whether it was personal service or service by mail. So I don't know if I could request a bench warrant, but perhaps a leave for motion to show cause.
Yeah, I have, in regards to Mr. Fuller, and I can't see, so I'm going to let it looks like the box is checked. I served a copy of the subpoena with any and all attachments on Brady Fuller. But let me make sure. I don't see a date though. And then I see that the court sent notice to the Holt address. And those boxes are checked. Let's see this on the back of this. I can't tell if that box is checked right there on the Brady Fuller. I don't see a date on that one. I thought the box looked checked. Just can't tell. No, all right. I think you're right, Mr. Burnett. Yeah,
Okay.
so we'll set for show cause.
Okay.
For defendants failed to appear. Service was questionable. All right, and that'll be set by the civil division. So you should get a date from the civil division concerning that show cause. All right, Mr. Burnett?
Okay, thank you, Your Honor. Appreciate it.
Okay, so that's all for the record in docket 1702060.
Okay. I believe that is all I have with the court this morning. Thank you.
Thank you, Mr. Burnett. Thank you for your appearance today.
Of course. Have a good one, Your Honor.
And then we have docket 18-04539. That's Case Credit Union versus Samuel Horton. Will the parties please introduce themselves for the record?
Good morning, Your Honor. John Hintz appearing for Plaintiff Case Credit Union.
And sir, you are Samuel Horton?
Yes, sir. Yes, Your Honor.
All right. And Mr. Hintz, have you had the opportunity to, this time set for discovery discovery matter in this hearing. I don't know, Mr. Hintz, have you had the opportunity to speak with Mr. Horton concerning some of these discovery issues?
No, I have not, Your Honor. I was wondering if the court would place us into a meeting room, and we could certainly talk and take care of this off the record and not clog up your docket at all.
Mr. Horton, would you be amenable to speaking with the legal representative of Case Credit Union in order to resolve some of the discovery issues in this matter?
Yes, Your Honor.
All right, I'm going to have Mr. Hintz and Mr. Horton placed in a breakout room.
Thank you, Your Honor.
Thank you, Mr. Hintz.
Thank you, Your Honor.
Thank you, Mr. Horton. Mr. Horton, you'll need to join the breakout room, so you'll have to push the prompt on your
Push
phone.
what?
There's going to be a prompt on your phone that'll indicate for you to go to the breakout room.
Nothing showing up on my phone.
You have a button that says breakout rooms?
Is there anything on your phone that would push an OK? There should be a prompt indicating to join a breakout room.
No, there isn't.
You have a button that says more?
Do you have a button that says more or
Excuse me?
OK? Do you have
No,
any button
it
on
isn't.
your?
There's nothing that's showing up right.
Let's get Mr. Kintz back. Maybe they can.
Showed-
Can you,
It showed at the onset, but I don't see anything right now.
Mr. Hintz, it appears that Mr. Horton is having trouble with the technology aspects of getting to the breakout room. Would you be amenable to Mr. Horton? Would you be amenable to having Mr. Hintz call you on your cell phone in order to facilitate this discovery?
Is it possible that I can redo this to get back to because it showed at the beginning about breakout room, but then right now I don't see anything.
So there was something that popped up. Well, let's try to put you in a breakout room again and see if you have a prompt.
Okay.
Okay.
Mr. Horton, did you get it?
No, I did not.
Should be a button at the bottom of the screen that says breakout rooms, and it looks like three dots. Yeah.
Yeah, there should be 3 dots, a button of 3 dots. I don't think he sees anything.
Your Honor, just to be fair, I didn't get a prompt to go to a breakout room either.
All right.
Okay, he's just moved. Okay.
Can you move him?
I already did.
If he's not seeing them, it might be because he has to tap the
He has to
screen to
tap
make
the
them
screen.
pop.
Mr. Horton, you might want to tap the screen and then the prompt will come up.
No, nothing.
Anything on his screen?
There, I
Is
see
there
him.
anything? You see it? Mr. Horton, is there anything on your screen?
Yes, now it does.
No, it does.
Get back to me. Okay.
All right, Mr. Hintz, I think did he just go in the breakout room? Mr. Hintz, I think he just went in the breakout room.
Okay, I will go. I'll go to I'm just going to hit the leave button and go to the breakout room.
All right, thank you.
Thank you, Your Honor.
I forgot what case we're on.
Mr. Rosencrantz.
Mr. Rosencrantz.
Your Honor, if I may, I'm sorry to interrupt.
Sure.
I don't have the prompt to go to the breakout room for whatever reason. I have the leave button, which would have me leave the entire meeting. And I was just in the breakout room earlier.
You were.
Yeah.
Can we put him back in the breakout room?
What does his screen say?
Or can you go back to room 2?
That's what I was trying, Your Honor. And I was in the breakout room and I was asked to come back to the courtroom. And so I did. And now I'm trying to.
Get back. Yeah, I don't have you. And there's nothing on your screen, right?
Yep, nothing on my screen at all.
There's a button that says breakout rooms on the bottom.
Yeah.
And if you just click it, it'll tell him to go. The prompt.
Yeah, he doesn't have that button. You don't have a button at the bottom of your screen that says breakout room?
Nope, it just says 54A room 4. And I've tried hitting the leave button, which would normally put me into the breakout room. And that just has me leaving the entire courtroom. Okay,
That work?
I have that you've moved me, so I'll hit try
Perfect.
the leave button again. Thank you, Your Honor.
Thank you. Thanks, Nathaniel. Did you move to a different breakout room?
I'm just put it back in.
Okay. So we're on the docket in docket 22-01831.
He left the meeting.
What's that?
He left the entire meeting.
Because if he hits leave, it doesn't ever go to a breakout room.
So Mr. Horton's just in the breakout room by himself.
All right. Well, I assume Mr. Hintz will come back, hopefully. So we're on the record in docket 22-01831. That's people, the state of Michigan versus Ian Rosenkrantz. Will the parties please introduce themselves for the record?
Jake Christie on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Rosenkrantz, who is standing to my right.
And sir, you are Ian Rosenkrantz?
Yes, Your Honor.
All right, Mr. Wisty, this is the time set for a final pretrial in this matter. How are we proceeding?
It is my understanding the defendant will be pleading guilty to the offenses charged in exchange for a Killebrew agreement that he be sentenced with a deferral pursuant to MCL 769.4A. So this is Jake Wisty speaking. This was the outcome we had discussed. If you have further questions, you can call my office, and it's been set for sentencing in September, okay?
Ms. Rosencrantz, did you hear that?
I didn't know he was talking to me.
All right, so the sentencing has been set for September 19th at 9 a.m.
You're saying the court date is September now?
It's the sentencing date. He pled guilty to the offense. So the
Okay,
sentencing date
September
will be September 19th.
19th. At what time?
Yeah, at 9 a.m.
Do I need to be there?
You do not need to be here, but Mr. Wisty's available from the prosecutor's office to answer any questions that you might have. So contact Mr. Wisty, and this was the case outcome that you'd previously discussed with him.
All right. Is he I believe his name's Jeff, right? Or starts with a J?
It's Jacob
Jacob.
Wisty,
Okay, so
Yeah.
I believe I have his number already.
and you will be contacted by probation in this matter for a statement, okay?
All right, thank you.
All right, thank you, ma'am.
Should I leave now?
You're free to leave, Ms. Rosencrantz. Thank you.
All right.
All right. On the record in docket 22-01849, people of the state of Michigan versus Tabitha Ellsworth. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Ellsworth, who is seated to my right.
And ma'am, you are Tabitha Ellsworth? All right. Mr. Wisty, this is the time set for a final pretrial in the matter. How are we proceeding?
Your Honor, the people will be dismissing without prejudice today. I've been unable to get in contact with the victim here. I left a message for him, and he's not here this morning.
There's no objection to that, Your Honor.
If I may approach, if the court could print out a
Nolly Cross?
I'm-
All right. So without objection, and may I inquire of your client concerning the dismissal without prejudice?
Yes, Your Honor.
Ms. Ellsworth, you understand that this case today is being dismissed without prejudice. I'm about to sign the nollie cross on it. That means that without prejudice means that the people could reissue if they choose to, but for today's purposes, the case is dismissed, all right? Okay. Ma'am, you are Marty Anna Rodriguez.
Yes.
All right, ma'am. Your lawyer's here. We're on some other files, and we'll call your case in just a second. Okay.
All right. Thank you.
All right. Thank you, ma'am. Miss MP, are you there? Grace MP? All right. So Ms. Hankins, you're here for your 9:30?
Yes.
All right, you're in the right place. So stand by until we call your case, all right?
Okay, thank you.
Are you represented by Ms. Robinson or Ms. Sutter
It's my
today?
client, Your Honor.
Okay, that's yours. All right. Did you need? Ms. Hankins, we're going to place you in a breakout room with your public defender, Ms. Robinson, okay?
Okay, thank you.
All right. An individual on the iPhone 2, would you please identify yourself?
Derek Ali.
Sir, say your name again. I want to make sure you're on our docket.
Derek Ali.
Derek Devon Lee?
Derek Ali.
Derek Ali. Sir, you are 1 day early. You're supposed to be here tomorrow for your file.
Oh, I'm sorry. Okay, thank you.
That's all right. You're in the right place. Just come back here tomorrow, okay?
Okay, then, thank you.
All right, thank you.
Yep.
And ma'am, with the moniker Queen, can you identify yourself?
Alicia Mataya.
Oh, thank you, Miss Mataya. You're here for your 9:30?
Yes, sir.
All right, and ma'am, you've got the name Queen. Can you please identify yourself, ma'am? The individual with the name Queen, could you identify yourself?
Oh, Nikita Harris.
Nikita Harris. All right, you're here for your 9:30s, Miss Harris?
Yes, sir.
All right, thank you. You're in the right place. Sure. So Miss Harris, you are not represented by counsel today?
No, sir.
All right, I'm going to give you the opportunity to speak with the assistant prosecutor on the case to see if you can resolve any of these issues. Would that be amenable to you?
Yes, that's fine.
All right, I'm going to put you in a breakout room with Mr. Wisty when he gets a chance here, okay?
Okay.
All right, thank you.
You're welcome.
All right, so I'm on the record in dockets. And these are the docket numbers 22-01556, 22-1604, 22-01605, 22-01608, 22-01609, 22-01610, 611, and 612. And I'll start with the 556. Let's see. Five, five, six. 611, 610,
The first, the
611,
1556.
612, 605. So we can find 604. There's 604. I don't see a 1556.
That's a different defendant, sir.
Oh, is it? Okay, good. All right. Will the parties please introduce themselves for the record?
Jake Westy on behalf of these people.
And you are Nikita Harris, ma'am?
Yes, sir.
All right, now I'm gonna have you speak up as loud as you can. Ms. Harris, we have you on 1, 2, 3, 4, 5, 6, 7 files. But we're just calling the first one on the record. Mr. Wisty, how are we proceeding today?
Your Honor, we'd like an adjournment about 2 weeks on all the files. The people are prepared to make an offer to Ms. Harris at that time. It'll be contingent on her getting the dogs involved to your license, which she says she can do relatively quickly. So we would ask for an adjournment in 2 weeks, and we expect to have a resolution at that time.
Ms. Harris, is that your understanding that we're going to ask for an adjournment from today's date for about 2 weeks in order for you to seek compliance in this matter?
Yes, Your Honor.
All right.
August 22nd at 9.
So the new date will be August 22nd at 9 a.m. And at that time, you should make sure and bring, you can do that by Zoom, but make sure that Mr. Wisty has any paperwork that you deem necessary for that pretrial, okay?
Yes, sir.
All right. So I'm going to adjourn all these files for August 22nd at 9 a.m. Anything else for the record on any of these files, which is 604 through 612, Mr. Wisty?
No, Your Honor.
Anything, Ms. Harris?
No, sir.
All right, I'll see you back here on August 22nd at 9 a.m. All right, ma'am?
Okay, thank you, Your Honor.
All right, you're free to leave. Thank you.
Thank you.
I'm gonna go ahead and write that in all these files. So. We're on the record in docket 22-01270. That is People, the State of Michigan versus Martiana Rodriguez. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Rodriguez, who is present via Zoom.
And ma'am, you are Martiana Rodriguez? Yeah, you're gonna have to unmute yourself, ma'am.
Sorry about that. Yes, I am.
Okay. This is the time set for sentencing in the matter. I have a pre-sentence report that was filed with this court by Danielle Strauss. Mr. Witz, you've had the opportunity to see that?
No, I haven't,
All right.
Your Honor. All the people are, is the cost recovery $1,031.63.
Yes, that $1,031.63 to LPD is part of the recovery. Okay.
People are in support of the recommendation.
All right. Ms. Sutter, you've had the opportunity to go over the pre-sentence report with your client.
Yes, Your Honor.
All right. Any additions, deletions, or corrections to the pre-sentence report?
We have a couple of corrections, Your Honor.
All right.
At the top of the report, it indicates that at the time of this report being created, fingerprints had not yet been completed. She informs me that she had those handled last week.
Okay.
So that is now completed. In terms, moving down in the employment section, at the time of the report, she was not employed and was preparing to take her CNA license exam. She has taken half of that CNA license exam. She passed the knowledge portion. She is scheduled to take the skills portion at the end of this month. She is also now employed. She is working at Holt, let me get the full name, Your Honor, Holt Senior Care Rehab. That's new full-time employment for her, earning, the base pay is $16.50 an hour, although she earns a bonus of $2 an hour as she has no calls in to that place of employment. So her excellent attendance as there has earned her some additional pay.
Right. And what was the before the employment? You said she had taken half of a CNA test?
Yeah, so the CNA license exam has two portions, the knowledge test and the skills test. She has taken and passed the knowledge test, 97% she informs me, and she is scheduled to take the skills test at the end of this month.
All right. So those corrections have been indicated to the pre-sentence report. Ms. Sutter? We still don't have the fingerprints. So you said she did those, she indicated she did those a week ago?
She said on Friday she had them done.
On Friday, so maybe they haven't caught up with the computer. Ms. Sutter, anything towards allocution?
Just briefly, Your Honor, I would by and large ask the court follow the recommendation of probation, that being the fines and cost sentence. I've discussed the victim impact panel with her as well as the alcohol highway safety course. That those being a couple of one-day classes that she is confident she can schedule and complete within that 90-day time frame. For the fines and costs, Your Honor, I would just ask that they be kept at a minimum for Ms. Rodriguez. As I said, this is very new employment to her while she's been studying for and taking her CNA license exams. She is a single mother of 4 children. There's supposed to be a child support payment or child support order in place for her children, but has never been paid on. So she is fully responsible for the care of her teenage children. And that's, as the court I'm sure understands, quite a lot for one person to handle. And so I just ask that all fines and costs be kept to a minimum for her. Thank you.
All right, Ms. Rodriguez, you heard your attorney speak on your behalf. Is there anything you'd like to say before the court indicates the sentence?
No.
All right, that's fair. I think Ms. Sutter covered it all. I'm looking at your CCH, and there's a limited CCH, but for driving while license suspended. I think the judgment of sentence is fair in this matter. So, and I understand that you've now had some success with employment and with the CNN first part of the exam. So I applaud you for that. I'm gonna indicate that credit is given. So no upfront, no jail. Credit is given for 2 days previously served. So you get 2 days credit. I'm gonna put fines and costs at a minimum, understanding your financial situation, ma'am. All right. So fines and
Thank you.
costs, I'm gonna indicate at $100 fines and $100 costs. There's a
Thank you.
crime victims right required fee of $75, a state minimum cost of $50, an assessment for the highway assessment of $90, and then a recovery cost from the Lansing Police Department of $1,031.63. You are to complete the following rehabilitative services, which the highway safety class is all that's requested. There's no probation in this. I don't see any probation.
Correct, Your
Yeah.
Honor.
I don't see any. The only applicable charges are to LPD. So no probation. And so the only thing you have to do is the one thing you really have to do is to take the highway safety course that was spoken by your attorney, Ms. Sutter. Do you understand that, ma'am?
Yes.
All right. Anything else for the record, Mr. Wisty?
No, Your Honor.
All right. Anything, Ms. Sutter?
No, Your Honor.
All right. So Ms. Rodriguez, take that highway safety and then make sure that you're in contact with the city of Lansing in regards to the collection on the payments, okay?
Okay.
All right. If you have any questions, keep in contact or at least call your attorney, Ms. Sutter. That's all for the record in docket 22-01270.
All right.
You're free to
Thank
leave,
you.
ma'am. Okay. Thank you. So we're on the record in docket 22-01556. That's people of the state of Michigan versus Valerie Hankins. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Erin Robinson, Assistant Public Defender on behalf of Ms. Hankins.
And you are Valerie Hankins, ma'am?
Yeah, yes, sir.
All right, and you can hear me all right, Ms. Hankins?
Yes.
All right. Mr. Whitsey, this is the time set for a pretrial. How are we proceeding today?
Your Honor, my understanding is defense will be seeking an adjournment. There has been an offer involving mental health court. Defense has just requested some 911 calls and would like an opportunity to review those before they advise their client.
All right, so the adjournment would be for discovery purposes.
Correct, Your Honor.
Is that a fair and accurate statement, Ms. Robinson?
It is, Your Honor, and I anticipate 3 weeks would be sufficient.
All right. So let's get a second pretrial date 3 weeks out for discovery.
August 29th.
So August 29th at 9 a.m. So Ms. Hankins, for discovery purposes, the adjournment will be to August 29th at 9 a.m. to look over some new information to be brought to the prosecutor and the public defender's attention. So you understand you'll be back here on August 29th at 9 a.m.?
Correct.
All right. Anything else for the record, Mr. Whitsey?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor.
All right, that's all for the record in this file 22-01556. Ms. Hankins, we'll see you back on August 29th. You're free to leave.
Thank you.
I have 29.
August 29th is a Monday, so it would be August.
Yep, I got the 29th.
Okay.
Yep.
So that's my bad, then I just wrote down wrong.
Mr. Rulison, you're here on the 10 o'clock motion. Oh, you're on mute, Mr. Rulison.
That's correct, Your
There you
Honor. It is Booker Hall.
Okay, is Mr. Hall joining us today?
He is. He should be on momentarily if he's not already.
All right, stand by, you're in the right place. We're just making sure I know who's here, okay?
That's fine.
Thank you. Ms. Hart, you're here for your 10 o'clock?
Yes.
All right. And then with the person from the Ingham County Jail mobile cart, identify yourself, please.
My name is Philip Stewart.
Philip, okay, Mr. Stewart, thank you.
No problem.
Ms. Robinson, who are we putting you in a breakout room with?
Ms. Mattia. please.
Okay, thank you. Ms. Hart, are you represented by counsel today?
She was denied counsel.
No.
All right. All right. All right. Ms. Hart, I'm going to put you in a breakout room with the assistant prosecutor, Mr. Wisty, so you can talk about resolving some of the issues in this case. All right.
Okay.
All right. So when Mr. Wisty joins us, I'll place you both in a breakout room.
Okay.
He was downstairs. I'm gonna, I forgot he came up here. Yeah. Okay, yes, I can do that. Can I take him back to this? No. Just don't want to. Just 2 seconds, sir. We just gotta take that super quick.
All right, thank you.
Sorry. Sorry, Your Honor.
Mr. Wilson, I'm gonna wait for the assistant prosecutor just to see if they have anything to say on those files. Those are resets, all 3 of those, that's correct?
I'm sorry, what was the question?
All right, well, hold on until.
Correct.
My understanding is all 3 of those files were reset for notice. Is that?
Yes,
is
that's
that correct?
That's correct.
All right. That's correct. All right, I'm gonna make sure the prosecutor's here when we call those files.
That's fine. Now, I can tell you that I can't talk with prosecutor on, not Mr. Wisty, but the prosecutor who used to work in your courtroom on Friday. And she'd had an opportunity to review the proposed order and had indicated to me that it was appropriate.
All right, that was Ms. Housefield?
Yes.
All right, all right. Thank you.
Okay. I had that Zoom meeting this morning at 10, so that's what I'm on right now. Okay.
But they were only doing scenarios like on a weekend, now they're another 10 trains. They do what they do.
Mr. Wilson, I'll call your case of dockets. Well, they don't have docket numbers because I'll call them in the original format of People versus Booker Hall. There are 3 orders to set aside convictions, and I'll indicate for the record. So, Mr. Wilson, your appearance for the record.
Thank you, Your Honor. My name is Stephen Rulison, and I am attorney for Booker Hall. My P number P37858. I do believe I have a written appearance on file.
And for the people?
Jake Wisty.
And Mr. Wilson, just I know just for the record. Oh, sorry. And you are Booker Hall, sir?
Yes, I am.
All right. For the record, this was a reset from a previous date to indicate that proper service was made, which it was. And we have 3 files for a motion to set aside conviction. My understanding is Mr. Wilson talked to Ms. Housefield that the substance of the order was correct. Mr. Wisty, I don't believe you have an objection to the substance of the order. Is that correct?
Correct, no objections, Your Honor.
Okay. And then Mr. Wilson, just so your knowledge, we took that order and we separated it into 3 different files so that it would reflect each file would reflect an order. And our person did that just so you know that I'm signing 3 different orders. All right.
That's fine, Your Honor.
All right. And Mr. Hall, by the way, the file indicates that you had letters of recommendation concerning some of your at least one of your previous employers indicating that you'd been a model employee to indicate on your behalf. So at this time, I'm going to sign all 3 orders to set aside the convictions. All right, Mr. Wilson?
That's fine, Your Honor. Thank you.
All right, Mr. Hall. Mr. Hall, I'm going to sign all 3 orders and you should be all set. Okay, sir?
Okay, thank you.
Okay, thank you, sir.
Your Honor, I have a procedural question
Sure.
for you. Will those orders then be forwarded to me for service on the Attorney General's office, or will the court actually do the service on the Attorney General's office?
I think the court returns them to you and you're responsible for giving or sending them to the Attorney General's office.
Okay. But certainly,
All right.
if they get duplicates, it's not going to be a problem. So I'll take care of that.
Correct. All right. Thank you, Mr. Wilson.
Thank you, Your Honor. Have a great day.
Your Honor,
Thank you.
I do have a note just to put on the record. The
All right.
reckless driving is going to remain on the Secretary of State record pursuant to statute. I don't think there's any issue about that, but just as a reminder.
That is correct, Your Honor. That is the statutory requirement.
All right. Thank you, Mr. Wisty. Mr. Hall?
Yeah, I didn't catch the last part about the Secretary of State. What was that?
There's still going to be a reckless violation on your Secretary of State abstract. All right.
Okay.
All right. So that's all for the record in these 3 files. Mr. Hall, you're free to go. Mr. Wilson, have a nice day.
All right.
Thank you.
Thank you. Thank you.
Sure.
So we're on the record in docket 22-01584. People of the state of Michigan versus Alicia Rochelle Mattia. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Aaron Robinson, Assistant Public Defender on behalf of Ms. Mattia.
And ma'am, you are Alicia Mattia?
Yes, sir.
All right. This is the time, and you can hear me all right, Ms. Mattia?
Yes, I can.
All right. This is the time set for a pre-trial in the matter. Mr. Wisty, how are we proceeding?
Your Honor, the people had made two offers. Either she could plead to a civil infraction or the people would support an adjournment for her to get her license back and would be dismissed at that time. My understanding is she has elected to attempt to get her license back. I think it would be beneficial to see her with a license. So we would be supporting an adjournment that needs 30 to 45 days is required.
Yes, please.
Okay, so adjourn for compliance purposes. I think a month, 30 days should be sufficient for our purposes. September holiday.
We can do into September. She has to schedule something for the Secretary of State, so that's what's dependent on and I'm worried about.
Let's do 1 week past. Let's go 1 week in September. Oh, just go past that.
September 12th at.
Okay. September 12th at 9 o'clock. This is a no ops file, right?
Yes.
Yes, sir. So I'll reschedule for September 12th at 9 o'clock and adjourn for compliance from both parties. Ms. Mattia, you understand that you're to be back on September 12th, and we're giving you that amount of time to become compliant in regards to your license. Do you understand that, ma'am?
Yes, sir.
All right. Anything else for the record in docket 22-01584, Mr. Wisty?
No, Your Honor.
Ms. Robinson?
No, Your Honor.
All right, that's all for the record in the docket. Ms. Mattia, if you have any questions, stay in contact with Ms. Robinson, all right?
Thank you so much.
All right, thank you.
Have a great day. Bye. I don't know how to, leave. Leave.
Mr. Blackman, I don't know if we have the fingerprints on Mr. Cooper yet received.
I think,
I know that he's done them. I just don't know that we have them.
oh, I don't know, we sent them to the court.
Yeah, that's, and Mr. Wisty was indicating, and I don't have proof of, so I have everything, but I don't have the fingerprints. And so, but I have that they were done. So that's the, so what I'm thinking is somehow the record of the fingerprints has not made its way to the file.
We sent the actual, when my client brought it back in, the actual fingerprint cards, we sent along with the application to the court.
May I ask a question?
Sure, Mr. Wisty.
So Mr. Blackman, I can see that he sent the card to the Michigan State Police with the fingerprints. And
Yeah.
correct me if I'm wrong, we may be waiting on the Michigan State Police to send something back. Did you receive anything back from the fingerprints?
I haven't, and that's been a problem always, but also my understanding that in 54A District Court, that what's been happening is they will not schedule a hearing for us on an expungement until they've got, that the court has got the sufficient materials. And I got a letter from Sean saying, and scheduling us a hearing, and it was the same thing I did with Mr. Patrick last week. We were in the same position.
Mr. Blackman,
Mm-hmm.
Mr. Farnham was scheduling it as in a time frame that we believe that we would reasonably have all the documents returned from the agencies that we were waiting on. We have found that they are now taking longer. You know, my guess is Mr. Farnham went ahead and scheduled this with the anticipation he would have had the required documents. So I'm not 100% sure.
Okay.
So, if we were going to adjourn this just for the, in order to get the fingerprints for the documents, how many days do you think we would need, Mr. Blackman?
You mean you would like my client to go back out to where they go to get a, go have
No,
it?
no, I don't think that's necessary. I'm just looking at so that adjourn it so that we can set it for a date, understanding that we don't have the fingerprints and we have not been contacted yet. And then I think I can go to Mr. Farnham and say, what do we have, what do we don't have, and go from there.
Whatever the court suggests, Your Honor, I guess.
2 weeks?
Yeah, that would be fine, Judge.
Yeah. My only take on it is to go back to Mr. Farnham and say, do you think we'll get them in 2 weeks? If not, let's have the hearing and we'll go from there.
Judge, how about 3 weeks? I'm gonna be, Judge, could we do it 3 weeks?
Sure, yeah, that's. So I'm gonna reset this motion. Can you do?
I think I can do this. Hang on.
All right.
Sean always does this, so let me just see if I can actually do this.
Everything else looks in line except for whatever reason, the fingerprints.
Okay.
And that they might be stuck with MSP.
Yeah, and that would be my understanding, Your Honor, is that the defendant has counsel did everything they could do, and we're waiting for Michigan State Police to act. And unfortunately, just need those to move forward.
I'll put a note in the file if Sean has any questions to contact me, so he can follow up to see if there's some reason why MSP's not forwarding the fingerprints to us.
Okay.
So August 29th?
At 9?
So August 29th at 9?
Yes, Judge, that'd be fine.
All right.
Does the court want us to do a new notice?
Yeah, we just did the notice, so,
Okay,
Mr. Blackman. So so no, we'll take care of the
Okay.
notice.
okay.
All right, and so Mr. Cooper, we're just waiting on fingerprints from MSP. And and I have a note from Mr. Farnham, who takes care of these files for us, that if they have any questions, call me. Hopefully by August 29th, we have everything we need, all right?
Okay, thank you.
All right. Anything else for the record, Mr. Blackman?
Nothing, thank you, sir.
Thank you, Mr. Wisty.
No, Your Honor.
All right, that's all for the record in that file. 201-841. That is people of the state of Michigan versus Philip Stewart. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Stewart, who is present via the jail polycom.
And sir, you are Philip Stewart?
Yes,
Okay, and you can hear me all right, Mr. Stewart?
yes, sir.
All right, Mr. Wisty, this is the time set for a pretrial in this matter. How are we proceeding today?
Your Honor, my understanding is defense is going to be filing to have Mr. Stewart evaluated for competency. Given that, I believe the adjournment is appropriate.
Is that correct, Ms. Sutter?
It is correct, Your Honor. He has already been referred for competency and a couple of other files by our office, and I do intend to file similar papers in the next couple of days.
Back door. For next Monday. All right. So we'll set a control date just to make sure that the paperwork comes in for 8:15 at 8. What time?
This is just a
Right.
control day,
Okay,
just a control day.
just for us.
Just for us.
Okay.
And for me to, in case Ms. Sutter gets busy, for me to remind.
For us, 8.
So just to confirm, I understood that there's no need for an appearance by myself that day, just to make sure I filed the paperwork.
Right.
Thank
Just,
you.
yeah.
Otherwise, the case will age incorrectly and it creates all sorts of fun.
Fair enough.
And Mr. Stewart's aware of this?
He is, Your Honor. He's had a number of discussions with attorneys in our office.
All
and
right.
Yes, he is.
So, Mr. Stewart, yeah, there's going to be a referral to evaluation for competency, and the file will be adjourned till we come back with something from the Forensic Evaluation Center. All right, sir?
Okay, they're also going to do the criminal responsibility, right?
Correct.
That's
Will you vote?
correct. Yes, Your Honor.
No.
All right, thank you.
Thank you. Anything else for the record, Mr. Wisty, on docket 2201-841?
No, Your Honor.
Ms. Sutter?
No, Your Honor.
All right. So this is adjourned without pretrial until we hear back from the Forensic Evaluation Center. All right, that's all for the record. in docket 21-00230. That's people of the state of Michigan versus Lawanda Hines. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence appearing on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Ms. Hines, who is seated to my right.
And ma'am, you are Lawanda Hines?
Yes.
All right. This is the time set for the violation of probation. Ms. Hagan, how are we proceeding today?
Thank you, Your Honor. It is my understanding that Ms. Sutter and I have reached an agreement on this file and that Ms. Hines intends to plead guilty to all of the violations except for violation number 14, failure to submit to PBT UA testing on a few different dates. The city would request to dismiss that violation. The city also would have no objection to any jail time be served on the weekend if this court deems it appropriate.
Is that a fair and accurate statement of the agreement as you know it, Ms. Sutter?
It is, Your Honor.
All right. So it would be, in my understanding, it would be pleading to the violations except for the last one, number 14.
Yes, Your Honor.
All right. All right. So, may I inquire of your client?
Yes, Your Honor.
All right. So, you understand that a request and summons for probation violation has been filed by Mario Ledesma concerning this file, ma'am? All right. I'm going to raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth on the penalty of perjury?
Yes.
All right. In regards to this file, it's indicated that you violated your terms of probation by failing to make a truthful report to the probation officer in May and June of 2022. How do you respond? How do you say? So you find it responsible for that count?
Yes.
All right. All right. In count 6, and they're not numbered. They're just numbered. They're not numbered chronologically. That you failed to pay fines and costs to court in the amount of $163 as of July 25th, with a total due of $470. Do you admit responsibility to that, ma'am?
Yes.
All right. And by consuming opioids while on probation on May 5th and per positive lab confirmation, you violated your terms of probation. How do you admit to that?
Yes.
Okay, and you admit to that, ma'am. Yeah, I find that the factual basis for the admission of the probation violation, I will dismiss the last count. So count 14 is, so D admits to 3, 6, 13, and 14 is dismissed. And if you, Ms. Sutter, have you had the opportunity to speak with Mr. Ledesma concerning any recommendation today?
I have not spoken with him, but I have reviewed his recommendation that he provided.
Okay, and he provided the recommendation. Is that on August 2nd, that recommendation?
Mine is dated July 25th, Your Honor.
I have a probation violation recommended date August 2nd. I don't know if that's the same, but would you like to take a look at that just in case?
Just to make sure, Your Honor. Yes, thank you.
All right.
May I approach?
Sure.
Thank you.
And you might want to show that to Ms. Hagan also.
Yes.
It's
Thank you,
just
Your Honor.
same thing.
You have just a white out date.
All right, thank you. So in regard to this right now, the probation is to terminate, my understanding.
That was my understanding as well.
Yeah, okay. Might want to mute that. So Ms. Hines, the indication from the probation department is they don't believe that you're a good candidate for probation at this time. Do you understand that? Is that a yes?
I'm
Okay.
sorry.
And that concerns me because that means that there's an inclination here that I believe that you may be a reoffender. You may come back in front of the court. There also may be a decision made that you won't benefit from probation. Do you understand that? Yes. You understand what a strange position that puts me in? That they don't want to work with you because they don't believe that continued probation will be helpful, but they're willing to give you a test run on your own to see that you don't get in more trouble. Do you understand that? Okay. So I'm not worried about you while you're on probation because you can admit and violate. I'm worried about you a year from now when you're not on probation and hoping that you've understood that this all needs to be put behind you, right? Yeah, you don't want to spend any more time in front of me, do you?
I know.
No, and yeah, and I mean, you have much better things to do with your time than this, don't you?
Yes.
All right, so I'm gonna accept the recommendation, all right? That you say, based on your word, I'm gonna terminate probation, all right? I'm gonna refer the amount of money left over to collections, so it's $470. Okay, I'm gonna refer that to collections, so you set up some payment plan with collections to take care of that, all right? And the only way we'll get in trouble is if you don't do that. If you don't do that, then you don't show up for your responsibilities, and then they'll put out a bench warrant for you, all right? So just keep in contact with them. I'm not going to impose any more jail on this, all right? There's a suggestion that there's no more probation, and my thought was, maybe a weekend in jail will have impact concerning the understanding that you don't want to spend any more time with me, right? You know, and I don't think I'm gonna bet you don't need that. Okay, I'm gonna bet that you don't want to spend any more time with me, that you don't want to be here. All right, I'm gonna bet that this is enough of an impact that you don't want to worry about that, right? All right. So so the termination is the admission's accepted. Your probation is terminated, and I'm going to refer the $470 to collections. And that's somewhat based on the recommendation that's in front of me. All right. So so I'm following what others are saying, and I guess what we're all saying, and what you're saying is you just don't want to be here anymore in this courtroom, correct? All right. So I'll refer the $470 to collections. Anything else, Ms. Hagan, for the record?
No, Your Honor, thank you.
Anything, Ms. Sutter?
No, Your Honor.
All right. So that's all for the record, docket 2100230. Thank you. So we're on the record in docket 22-01825. That's people of the state of Michigan versus Carissa Hart. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And ma'am, you are Carissa Hart,
Yes,
and you can hear me all right, Miss Hart?
yes.
All right. Mr. Wisty, this is time set for a pretrial in the matter. How are we proceeding?
Your Honor, we'd like to set for a final pretrial. An offer was made to Ms. Hart. For the record, it was pleaded to a reduced count of charge of trespass and restitution in the amount of $163.66. Ms. Hart has rejected the offer, and we'd now like it set for a final pretrial.
All right, so set for final pretrial on 8/22 at 8:30. So Ms. Hart, at this time, this is set for final pretrial, and you're to be back in this court on August 22nd at 8:30.
Okay, are you guys gonna
Oh.
send me that in the mail or is it the same Zoom meeting?
We'll send you that in the mail, but that you should appear live for that final pretrial, okay?
Live, like in court?
Yes, live like in
Okay.
court.
Okay.
All right. All right. So anything else for the record? Docket 22-01825, Mr. Wisty?
No, Your Honor.
Ms. Hart, anything else?
Nope,
All right, you're free to leave. Thank you.
thank you.
record in docket 20-02617. That's People, the State of Michigan versus Derek Lee. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Assistant Public Defender Lauren Sutter, on behalf of Mr. Lee, who was seated to my right.
And sir, you are Derek Lee? Okay. This is the time set for a plea in this matter, I believe. Mr. Wisty, how are we proceeding today?
We've reached an agreement where Mr. Lee will plead guilty to an added count 2 trespass in violation of MCL 750.522. That's 30 days and or $250. In exchange for that, count 1 retail fraud will be dismissed. We would also need a restitution hearing at sentencing.
All right, I'll restate the negotiations for the record, and Ms. Sutter, you can indicate if I've written them down correctly. Mr. Lee is going to plead guilty to an added count 2 of trespassing under 750.522. That's that's 30 days as a maximum penalty or $250 fine with a plea to count 2 retail fraud in the count 1 is to be dismissed. And at this time, any restitution will be determined at sentencing.
That's correct, Your Honor. The place in question no longer exists. So I think in order to figure out if there's anywhere to even pay restitution to, if we do that, we would have restitution.
Okay.
That's accurate.
May I inquire of your client?
Yes, Your Honor.
Mr. Lee, is that your understanding of the plea agreement?
Yes.
Okay. So you understand, Mr. Lee, that the maximum penalty you can get is 30 days on the added count 2, and the maximum fine is $250. Okay. Miss Sutter, may I inquire of your client concerning their rights concerning trial?
Yes, Your Honor.
All right. Sir, if you plead guilty today to count the amended count 2, you will not have a trial of any kind in this matter. And so I'm going to detail those rights you have, those rights you would be giving up. You'd have the right to have witnesses called in your defense. You'd have the right to cross-examine all witnesses. You'd have the right to testify to remain silent without an inference being drawn from your silence. You'd have the right to the presumption of innocence, and you'd have the right to have your guilt be proven beyond a reasonable doubt by the people of the state of Michigan. Do you understand those rights, sir? Yes. And you're represented by Lauren Sutter, the public defender. She would be able at trial to contest any charges against you and bring a case against the charges or cross-examine any witnesses. Do you understand that? Yes. And you are waiving your rights today to go to trial, and you're pleading guilty. Is that right? Yes. And you are pleading guilty because you are guilty, sir? Yes. All right, I'm going to bring your attention back to April 2nd. Oh, I'm going to have you raise your right hand, sir. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Yes. All right. I'm going to bring your attention back to April 2nd, 2020 at 430 East Edgewood Boulevard, City of Lansing, Ingham County, State of Michigan. Were you at that location at that time in the city of Lansing? All right. And at that time, did you knowingly trespass upon property that you knew you were not supposed to be on? Okay. So I find that to be a factual basis for trespassing under 750.522. Mr. Wisty, anything on the factual basis?
I would just, Mr. Lee, it's not related to the trespass, but did you take a fire pit out of the store that day?
Your Honor, I would object to that. I don't believe it's necessary for the factual basis for what he is pleading guilty to, and I would advise him to not answer that question.
Right. I don't think I can get into the retail until the dismiss count. So I can only indicate that he was in a place that he knew he wasn't supposed to be.
Withdraw the question.
All right. That's all right, Mr. Wisty. I understand. And we will determine restitution as a part of the factual basis. Anything else, Ms. Sutter, on the factual basis?
No, Your Honor.
I find the plea to be understanding, voluntarily, and accurately given. I think I have to send this to probation in order for something to be done to determine whether there's a person, whether we have restitution in the matter. Mr. Wisty, any comment on that?
I mean, really, I think what needs to happen is the store itself is no longer in service. I'm trying to track down who actually suffered the loss at this time. So realistically, at sentencing under restitution, I think that's going to be the sole issue.
Okay, Ms. Sutter, did you, so do you want it referred to probation for restitution only, or do you want it for a full restitution report?
I mean, personally, Your Honor, I would ask that we do immediate sentencing today. I don't think there's anybody to pay restitution to.
Right.
My understanding is this company filed for bankruptcy several years ago. There is no entity, legal entity or business entity for any potential restitution to be paid to. So I would ask for immediate sentencing, though I understand Mr. Weston has a different position.
My understanding is the company was sold. I mean, there may still be a legal entity out
Right, I guess that's my fear, that some restitution is paid to somebody in the matter and there should be some follow-up rather than immediate sentencing. I just don't know, and that's what scares me, is I don't know. So I'm going to refer to probation. So probation will talk to your client within 48 hours. I guess that's the best way to put it, right? Yeah,
That would be contact with them via they'll make an appointment.
Right.
Like
and do we have a sentencing date?
9/19 at 9:30.
So sentencing date is September 19th at 9:30. Anything else for the record, Mr. Wisby?
No, Your Honor.
Ms. Sutter?
No, Your Honor.
All right. Mr. Lee, we'll see you back here on September 19th at 9:30. It appears to make a real determination of whether there's restitution in the case, okay? All right, thank you. That's all for the record in docket 20-02617.